the recording machine. Yeah. All right. Thanks. All right.
Well, those of you who joined early, we live, and I'm just hoping that this equipment's working. So, all set up. How does that look? Oh, not bad. Good. So who wants to be interviewed meantime on my live stream?
I'm literally like not even like made out, like I'm going to be fair, my client has not given me the instructions to, so I can't tell my client
So if you hear all that joking in the background, that's Thandeka from the COURS team are all here early, and I'm suddenly trying to ambush them with a video with an interview, and they weren't ready for it. But anyway, it's a great day. I'm just welcome anybody who's joining. To say that hard to know what sort of feelings I'm going to feel after this, because that's unprecedented. Good. So you've consented, Thandeka.
I won't be here for long, George.
Thandeka, welcome.
Thank you.
Congratulations. You've just got back from Oxford.
Yes, I did.
Why don't you tell us a bit about what you were studying there?
Oh, I was studying. I was doing my master's in international human rights law. So I graduated, I think, a week ago, 2 weeks back. So it's good to be back home and to be fighting the good fight.
Good. Oh, that's great.
Yeah.
And what say a bit about what led you to take an international human rights law?
I think obviously as a human rights lawyer already, I was already practicing as a human rights lawyer at COURS. Am I audible? Okay, I was already practicing as a human rights lawyer at COURS, and we use a lot of international law in South Africa, and so I just wanted to know like what to do in order to make to fight better, because we're also fighting a lot of international corporate people. So we also wanted to know the sort of the law governing business and human rights, the law governing, the international law governing those things.
And what's it about this particular mining enterprise or enterprises that has caught your attention as being about human rights? Say a bit about how you got aware of this and what you're seeing playing out.
So we came in as amicus in this case, and we were arguing that this case has the elements of what is called a SLAPP suit, or strategic litigation against public participation, which is aimed at silencing activism more than anything else. Because what happens is that when there's a SLAPP, the next person who wants to bring a legitimate claim or who wants to voice out something are unable to, because they are scared, because they see that the people before them had to go through a lot of legal sort of had to go through a lot of legal hurdles. And
I mean, when this whole process was getting underway about 5 years ago, when the human resource, when the Weber Wenzel attorneys were helping us get our mind around it, we looked at international experience, and we were advised that the best way to deal with the SLAPP suit is to make sure they don't win it. You know, because we're saying there needs to be legislative change, we need to have some statutory protection against it, the abusive process. And you know, when they said that, I thought, because I was hoping at that stage that, you know, maybe 2 years, and we would bring closure on this thing, and I'd go on, and we'd have changed, Parliament would have enacted legislation. 6 years later, we're at the cusp, and obviously for me, it's quite a an important moment, because, you know, from my perspective, I've just been doing my job as a social worker, which is about using the Bill of Rights and human rights as a basis for dealing with conflict. So what's your feeling, having watched, I'm sure, the proceedings? What is your gut feel telling you about where this is going to go?
I mean, you never know, right? But we do hope that justice will be done today, because, I mean, SLAPP suits are a form of activist victimization, you know, and in this country where a number of people come from very impoverished backgrounds, where they are unable to go to court on a number of issues, the only thing that they do have is their voices. The only thing that they do have is the right to go and protest. And, you know, and when they are being victimized by a mind, to say this man is victimizing me. So if you take that away from them, what are they left with?
Exactly. And in fact, what's been interesting since having got involved for this long period with the Amadiba and the community at Kolobeni, and then seeing the Tormund mine come into focus, and the excellent work done by, you know, the Centre for Environmental Rights and championing those issues, I found myself over the last 2.5 years now working with whistleblowers. And it's interesting, because there seems to be a, you know, Judge Goliath talked about in her judgment that this bears all the hallmarks of a DNA of a SLAPP suit. Well, there's also abusive legal process against whistleblowers, which I'm calling slow suits, strategic litigation whistleblowers, where the weaponized use of disciplinary procedures, which then keep them trussed up and bound up to the point where it's just a litigation by attrition process where they're just exhausted. And then, of course, there's strategic litigation against media, slam suits. So I'm now talking about the family of illegitimate children, let's call it that, you know, or
It's
of a way of actually
being the umbrella,
the umbrella,
you know,
and
other parts.
and I'm trying to get a concept or a metaphor around it. So in that sense, do you agree with me that the outcome of this judgment, what are its ramifications for others?
I mean, we are very hopeful. I can say we're very hopeful that the SLAPP suits are recognized in South Africa, because at the moment they are not. I mean, Judge Goliath did sort of say it has the hallmark of the DNA of the SLAPP suit, and sort of said that they were recognized, but that's in Cape Town. But throughout the whole country, like SLAPP suits are recognized. Right? So we are hoping that the court today recognizes that, you know, powerful players can use the law in a way that, you know, is an abuse of process. So that's what we're hoping for.
Well, thank you. And when's the party? Is Cal going to be? Do you have the budget? Because
We don't have the budget for a party, John. We don't.
no, it's been very encouraging for those of us as respondents to see that there has been this interest from Amaki, friends of the court, and you know, to have two yourselves and those human rights as well, it really does show that this is important, and I'm sure that the judges recognize it. I've been with them, so it's taken so long. Hopefully it's because I'm thorough, and either way, I mean, I feel a little bit cheated, because, you know, right from the word go, I was so keen to be there. I was so keen to be able to defend the claims that we made, because I knew that I was speaking the truth and it was in the public interest. But my lawyers kept saying, John, you're never going to get to court, so don't get too excited and don't fantasize too much about what that would be. Because, I mean, in my involvement with this kid here, it's really trying to engage with nothing. So look, you know, mining rights must be subordinate to human rights. and environmental rights.
Yeah.
And we live in a constitutional framework in this country, which I think they didn't fully understand coming from Australia, because Australia doesn't have a written constitution. It doesn't have a Bill of Rights. It only uses common law. And defamation suits are quite common there. So I think that they probably had this idea that somehow that this is a way you deal with these troublesome people, you just slap them. They need to find that it's actually quite fine. And I find it strange that they actually turned it into a kind of a class action process, because they're not only the first day after me, then they went after 200, Cullinan, and then astonishingly, they went after Christine, Tracy, and Baby on formula. And I thought to myself, this is really, what they've done is created a solidarity of interest. And I mean, I'm not at the point of wanting to say thank you to them, because I think it's still immoral.
Yeah.
It might have seemed to be lawful, and this is the default option. And it has had a tremendous, difficulty. But I'm seeing hope that this will be a kind of a crossing of the threshold. The last thing, this is about freedom of expression, not the Bill of Rights, basically underscore that. However, it's so important that widening space between is used with even more responsibility for people to speak out without fear of constraint. So that's my thought.
I totally agree, because what this case has done is that over a number of years, like 6 years, like actual attorneys who are representing people, have defamation suits against them. You can imagine how scary that is for upcoming attorneys, who want to do human rights work. It's like, okay, if I do human rights work, I'm going to be subjected to a lawsuit myself. So that's how I'm excited and looking forward to today, because at last, we will get a resolution.
That's amazing. Yeah, and I mean, South Africa, it's a place where you can have this legal innovation. I was interviewing Judge Davis just recently on my YouTube channel, where we were reflecting on, in fact, this case and then generally, because he's always been this stark advocate of the fact that the Bill of Rights is not just mere text. It's not just something which is, a document to hold government accountable in its powers. It's actually a basis for society to mobilize and organize, and that human rights actually belong to people. So in that sense, I'm very excited that this wish more social workers had that sense of, and hopefully they will know, that our job is to actually make sure the Bill of Rights is meaningful, so that we can maybe get justice without this expensive, tedious litigation by attrition. Although it does create jobs for lawyers.
I mean, it does. Thank you so much, John.
Thank you, Patricia. Thank you. Good. Great.
That was a warm-up from your side as well.
That was. Thank you. Yeah, I'm sure I don't know how many people we've got online. We're still getting the hang of this. But I have 7 so far. I just need to make sure I've got enough data on my cell phone, because the last thing we want to do is see the live stream suddenly end, as happened when I was the live stream. And let me tell you this funny story. I was also monitoring the Senzo Mayiwa trial, and which funnily also happens to start again today. And this was about 6 weeks or so ago. And it was the day upon which one of the witnesses, Tumelo Madlala, was due to take the stand. Now, it's not funny, but what is funny is that all this SABC, ENCA, and Newsroom Africa cameras and journalists pursued the poor guy to the point where he felt intimidated and harassed. And as a consequence of it, the judge decided that they would have to go and sit in the naughty chair, and were expelled from the court with their cameras, which then left the public with a huge interest in this matter, having to countenance this amazing trial without any coverage. So I hastily took out my cell phone and learned very quickly how to do a live stream onto YouTube on my mobile to at least give people some access. And in no time at all, it just mushroomed. Only problem was I ran out of data. So I had to send an apology. And I was having people saying, we'll donate data for you. We'll give you 5 gigabytes. Just please get yourself going again, because there was no coverage. I did get data and resumed the coverage. But then, of course, the judge's clerk happened to notice me there with my phone and decided to unfortunately kick me out as well. But such is life, and this time I made sure that I've got consent to be here. The funny thing about it is that, you know, as a social worker, I always love to see the media working in a more joined up way. But there's always rivalries between them. And afterwards, when I engaged with them all outside the court on the pavement, they were all saying, you know, I found it just unbelievable that this was happening. And they all confessed. They said, yes, we were all responsible. And it was a ironic sort of unification of these rivalrous media people, all interviewing me to find out what had happened inside. Anyway, so I'm waffling on to share that just because I want to make darn sure that I have got enough data on my phone, and that if needs be, anybody wants to donate some, they're welcome. Unmute. To whilst we're waiting, we've got another 15 or so minutes. I've got Kristen Callison with me. Now, Kristen is a environmental activist who is watching the outcome of this particular judgment with very keen interest. Kristen, do you want to tell us why?
We've been sued with what we believe is also a SLAPP suit. Myself and the conservancy that I chair have both been sued for 197 million rand by a property developer. And so, yeah, we're looking to see what the judgment comes out today and whether it makes a ruling on SLAPP suits going forward. They should be thrown out of court, or whatever the outcome is. We're interested to see what that is.
You're very modest, and I'm actually a little bit envious because I thought I was doing well out of them of getting 10 million rands in defamation claims. What is your claims against you? Is it 193 or 290? I can't remember.
197 million plus even opens the door for future charges as well. So it's at least 197 million is what they're asking for.
And it's not as though you were going out deliberately to defame. You were just following environmental legislation and holding them accountable for what should happen.
It's not a defamation suit. It's actually a lawsuit for costs which they allege due to delays for construction. So it was due to objections we laid during the public participation process.
I see. Okay, but it all amounts to a slap. It's just, and in
We
fact,
believe so, yeah.
it does. And there's different, variations of slaps. There's against the media as well. It's against, whistleblowers. But I have to say, for folk, it was interesting. After the Goliath judgment came out, as far as I was concerned, that was the victory, and that it was, time to celebrate. And I really said, look, I don't think I can keep going on this thing. And Melissa Fourie called me from Centre for Environmental Rights, and we had a chat, and she said, John, please, this is not the time to allow, effectively, defeat to be snatched from the jaws of victory. She says, we have to go and get this judgment of Patricia Goliath set in sort of constitutional stone. And so I spoke to my wife and my friends, and I said, well, look, okay, let's keep going. Of course, it would be silly and self-indulgent and selfish not to. And then she told me about Kirsten, who's now since become a good friend and been very helpful. And it's so nice to be able to see that this is not just about us. It's not just about this particular thing. It's about a universal institutional way in which South Africa governs itself.
Yeah, and these lawsuits affect, there's quite a few people, even in the last couple of years, that I've come to know that have been faced with similar kinds of lawsuits. So it'll be very important and hopefully protect the rights to people to be outspoken in public participation that our Constitution enshrines.
It is, yeah. Well, thank you.
Thank you.
So when's the party?
Well, let's wait and see. Yeah, but we do appreciate very much your support and that you guys have been prepared to follow this through, because I think it's very important.
Well, I mean, I have to say, I was really just doing my job. I mean, I was able to do the job of a social worker, maybe with a greater measure of shall we say, adventure, because I have privilege, and my wife has been able to support me, because that's why most social workers couldn't imagine doing this, because they're employed by the state. But in terms of our professional code of practice, we are meant to ensure that the rights of our clients are upheld and protected and exercised. And one of them is the environmental rights of them and the freedom of expression and all the rest, as a basis of ensuring good governance. So in that sense, it's nice for me and satisfying to me to know that this has had ramifications which go beyond just the particular. We're talking about universal, right? Stay here, and it's about South Africa getting itself out of the dwang. I mean, because we are in a serious state, and hopefully this can be one of those beacons of light that actually say, look, it's not all doom and gloom. Don't rely too much on the executive or the legislature, but let's hope that at least the judiciary is able to hold the line. Agree.
Absolutely, absolutely. And I mean, talking about the state of South Africa, I don't know if you noticed, but I parked on the street and walked up, and the amount of homeless people at the moment living in the constitutional precinct is quite eye-opening. You know, right here at the Constitutional Court, on the steps of the court, are, I don't know, I think I passed about 60 people outside that are sleeping out here. Through the rains that we've just had, you know, South Africa really does need to turn around quickly, because there's a lot of people suffering at the moment.
Yeah, no, this is a protest against, I think it's the Minister of Human Settlements, for the failure to provide adequate housing and shelter for this group, which, you know, is, you know, and of course, paradoxically, Mark Caruso in one of our exchanges, and I said, look, you know, you can't violate human rights. And he said, well, what do human rights matter if people, he said, no, they do matter. He qualified himself. He said, if people don't have jobs, if they don't have income, if they don't have shelter, he says, no, living in abject poverty and mud huts. I mean, that was his narrative. And there's a sense in which he's right, in the sense that socioeconomic rights have to be vindicated if the Bill of Rights is to really become meaningful. Obviously, you know, he didn't engage me long enough for me to explain to him that if he had a broader view of it and followed a rights-based approach, which insisted himself on ensuring the free, prior, and informed consent of the Amadiba community, well, maybe he would have had a better chance of mine. Use that as a sort of rationale, as a rationalization for just not taking responsibility. And that's all I was trying to do with the guy. I said, look, we live in a human rights culture in this country. How does this compare to the United States, your home?
I haven't lived there for 28 years or so it's been a while. But you know, as I was walking up and looking at this, I was remembering pictures I've seen of Los Angeles, where they've got a huge homeless problem at the moment. So, you know, worldwide, we've got huge economic issues, human rights violations, and governments that are squandering the resources or stealing the resources. And so the needs of the people are just not being met. So good governance, following the Constitution, ensuring that the laws are upheld is critical.
Good. Yeah. Well, hopefully you'll send some goodwill messages to your family, and they will take some lessons from us. Yeah. I mean, there is because the United States is also a constitutional democracy. It does have the Supreme Court. It does have ultimate recourse, which of course.
But it certainly has problems, and that's also quite well advertised.
And has been so politicized. And of course, it's a vexing thing because judges are human. But I'm confident today that, given the fact that we've got such incredible counsel, in my dreams would I ever have imagined that I would have the father and son team of Jeff and Steve Budland, who I've been following and watching for a long time, basically going into bat for us. And I think even the folk on the other side were a little bit intimidated by that. Oh, that's so nice to see all my friends coming. There we go. Thank you. These are friends of mine who have just arrived from my Ruah community, my church community, who were praying for me yesterday. Thank you. Thanks, you. Oh gosh. So there's some festivity and joy between
people that haven't seen each other for a while.
Oh, it's so lovely to see that deep fellowship of lawyers. Anyway, I don't know what that's about, but it just shows this Constitutional Court is proving to be a place where connections are made and goodwill is cultivated. Good. I see Mzamo Dlamini has joined in the chat. Mzamo is one of my co-defendants and the guy that really got me involved in the first place in the whole Olubeni saga. And he was my trail guide and taught me how to ride a Pondo pony 22 years ago. And I fell in love with the wild coast and felt that I'd stumbled in on paradise. I thought this place was just amazing. And it was just inconceivable to think that, that there was ever going to be the prospect of people coming to mine paradise. So that declares my interest in this matter, and it was more than just a kind of a recreational interest. There's something of a spiritual significance of the place, of being re-enchanting my, that stage, rather disillusioned and despondent view of where things were going in South Africa and on the planet. So, Mzamo, thank you. We've got lots of funny stories to tell, and you'll tease me by telling them. I'm also glad to see Russell Clemens, all the way from Perth in Australia. Now, Russell's become a really good friend. And I've never met him face to face, but this just goes to show the power of the internet. I met him through another network. We have a common interest in managerial cybernetics and systems thinking, and one thing led to another, and he heard about what I was doing. And the fact that he was from Perth, which is where the mining company is headquartered, he has been extraordinarily helpful as part of the shareholder activism that we have initiated in 2007. And the background to that is that I happened to hear Judge Mervyn King talking about the ideas of the triple bottom line and this, the global, economy of accountability, etc., and how businesses needed to be held accountable for ensuring holistic reporting, etc., etc. So through our connections there, we had two people buy shares in the mining company and turn up at the AGM and started asking questions. That wasn't Russell himself, but it really, unfortunately, gave Mark Caruso, I think a problem of, and he realized that wasn't going to be easy for him, because thanks to citizen shareholder activism and the media, we've kept the heat on them, and MRC and lodged complaints with the Australian Stock Exchange about what they've done. So you can understand, and I really do understand, why he taken exception to what we're doing. But it hasn't been me. It's just been good, clever strategy. It's just been connections. And Russell was one of them. Russell was, retired civil servant who worked, and he's a very clever guy. And he took an interest in this and has been keeping me posted on what's actually been happening on the other side of the pond. So, Russell, please, I want to give you huge credit for your support, and Louis de Villiers, Sizonke Msumang, who also lives in Perth, have all in their own ways helped, as well as the two journalists who the two people that the activists who turned up at that AGM in 2007. I just call them Arthur and Martha. And I've written up on my Medium channel. It's called The Real Truth About MRC, and it's one of the publications that Mark Caruso has taken exception to and has claimed against me for, I think it was R1 million for the things I said there. But I mean, if my attorney would, maybe I better check with her before I tell you the rest of the story, and let's wait for the judgment. But suffice to say that I knew that what I had to say was true. I had activists in Australia who had been verifying, who had been testing. I had connections in other parts of the world to see how their mining operations in, for example, the Solomon Islands. So this is really, I think, why this whole saga has taken so long, because it speaks to the way in which the industry works and how they have used defamation and SLAPP suits and abuse of legal process, because we have freedom of expression, we have a media, we have all these instruments of accountability, and they can't get away with it. And they mustn't get away with it, because I've just been monitoring and watching what's happening in COP. And in some ways it's ironic, because both Nonhle Mbotuma and Sinagogu Zukulu are the two leaders in the community that have been so seminal to the whole struggle, together with Mzamo and others, that they've both been speaking at COP. And I think it needs to be said that this is not just about the social worker and the lawyers and the activists, making life uncomfortable for a mining company. This is about the consciousness we need to have about the way we treat the planet, and how so important it is for those with power and money to subordinate their interests to what in South Africa we have in our Bill of Rights, Section 24, the right to an environment that's protected for the benefit of present and future generations. And so, Sinagogu, Nonhle, if you're still there in Cairo, strength to you, thank you. It's been an extraordinary process. And I'm getting all the words in now, because later on I'll probably be at a loss for them. I see it's 3 minutes past 10 and we're waiting for the judges, so we ought to start. So let me stop talking and refocus the camera. There. Pleased to see there is our intrepid attorney, Murray Hawthorne, sitting to the left of your screen, looking at us. And yeah, whilst I've got this space, let me pay tribute to Murray. He is just one of those lawyers that really restore faith in the profession and restore confidence in the public that the law can be used as an instrument of ensuring social justice. He's been, for all his career that I've known him, on the running the pro bono division of Weber Wenzel attorneys. He's now supposedly retired and having reached retirement age, but he still works as a consultant.
May it please the court, Justice Majid, I appear for first weekend in 66, and first respondent is in 67. We don't have to say. Does the court please? Just give us your name. I apologize to the Justice. I am Kenny Kumre from the Johannesburg Society of Advocates. Thank you so much.
referring to actually for the respondents in case 66/21 and the defendants in 67/21.
May I speak to the institutions? My name is Patricia Stanley, I'm a journalist with I have the pleasure of appearing before you. So I take the liberty to introduce myself. I appear for the amici in this matter, the Center for Practical Studies, and the Lawyers for Immigrants.
During this court has come judgment in two applications for leave to appeal against the judgment and order of the High Court of South Africa Western Cape Division. The underlying proceedings in the High Court concern the alleged defamation of two mining companies and their office bearers by a group of environmental activists and lawyers. The mining companies are Mineral Sands and Resources Pty Limited and Mineral Commodities Limited, joined in proceedings by two of their office bearers, Mr. Zavele Tumia and Mr. Mark Victor Caruso. In the interest of brevity, these parties are collectively referred to as the mining companies. The environmental activists are Ms. Christine Riddell, Ms. Tracy Davies, Mr. Ray Peter, Mr. Nzamo Dlamini, Mr. Cormac Cullinan, and Mr. John Gerard Ingram Clark. In the interest of brevity, again, these parties are collectively referred to as the activists. Those matters before this court arose from three consolidated actions in the High Court, in terms of which the mining companies issued summons against the activists for defamation. The claims were based on the activists' critique of the mining companies' operations, activities in the Tormund and Torabay mineral sands projects on various mediums and platforms. Mining companies sought several awards from the High Court against the activists for general damages in the sum of 14 million rand. In the High Court, the activists raised two special pleas. The first is the strategic litigation against public participation, or SLAPP, suit special plea, and the second is the corporate defamation special plea. Mining companies raised exceptions to both special pleas on the ground that they do not disclose proper defense in law. CCT 66/21 was an appeal against the High Court's dismissal of the mining company's exception raised against the activist SLAPP suit defense special plea, where it held that the SLAPP suit defense special plea indeed discloses proper defense to the claim for defamation. Case CCT 67/21 concerned an appeal against the High Court's upholding of the mining company's exception raised against the activist's corporate defamation special plea, where it was held that such a defense was not founded.